Hi there, I'm Simon Bennett and welcome to the OMB Law Board. So pleased to have Abbi Golightly, partner of the OMB Family Law Team, back today. Welcome, Abbi.
Thanks, Simon. I'm glad to be here.
Abbi, this is a hot topic. Prenuptial agreements, or you call them financial agreements or binding financial agreements. Can you explain what they are and how we use them?
Absolutely. So prenup is, I guess, what people commonly know financial agreements to be. That being said, they're also called binding financial agreements. So there's lots of different terms for the same concept, which is effectively a private agreement between parties to a relationship that will divide their assets if they have already separated, or what can happen if they separate in the future. So that's your prenup style agreement. The word binding financial agreement isn't in the Family Law Act. They're called financial agreements. But again, much like prenup, binding financial agreement has become what is commonly referred to.
Yeah, so prenup is the thing that we all hear, right? If we're watching TV or listening to the radio, you're getting it, you're in a relationship, you need a prenup, you've got to protect your assets. Can you dive into a little bit about, do they work? Are they binding? And what use are they to me?
Yeah, absolutely. So are they binding really depends on how well they're put together, which is why you need to get an experienced family lawyer to prepare them. There's lots of services out there. There's online drafting services. AI has started to step into that space as well, that pump out template agreements that are designed to give people the comfort that their assets are protected. Can I tell you, relying on those automatically generated style documents, you're walking into coming to see me about having that agreement set aside down the track.
Yeah, no surprise there.
Absolutely not. So to make these agreements binding as you want them to be, it's important that all of the boxes are ticked. So the Family Law Act has really specific requirements for what needs to be in these agreements. And then the other aspect is to make sure that you get the required legal advice before you sign off on them. If you don't get independent legal advice, and that's truly independent legal advice, then the agreements can be set aside down the track, which is exactly what you don't want to happen.
Yeah.
When it comes to your prenup style agreements, that's designed to protect your assets. It's important that at the time you enter into them, you provide complete disclosure of what your financial position looks like. So the style agreements that simply say, that's mine and that's yours, without saying what is within those categories, is problematic. So it's really important that all the cards are laid on the table.
Yeah. So particularly I think of the situation where we come into a relationship and the existing asset pool is really differing. So one party has a lot, one party has very little.
Yeah.
It seems to be a situation that we should definitely be looking for that type of agreement.
Yeah, so when we're thinking about our financial future, it's important that that comprises part of the consideration of asset protection. So, again, tying in with estate administration and estate planning, family law planning and asset protection is really important when there is that difference in financial position at the commencement of the relationship. It's really beneficial, particularly if it's a relationship that's not your first. Yep. So perhaps when you've got a more mature couple coming together after having built assets previously, and they both acknowledge that, well, that is what you've done. Independent of me, I've contributed nothing to that. So it's important that you have that for your future and for your family's future moving forward. So those prenup style agreements are really beneficial for those types of relationships. But importantly, they need to be reviewed. So when your relationship has been ongoing for a period of time, and there's no sort of set sliding scale, but I recommend every 5 to 7 years that you sit down, you go, right, what does our financial picture look like now? Do these assets still exist, or have they morphed into something else? Have we accumulated things together? How do we manage that if we separate?
So we can do an agreement at the start or as the relationship forms. We can also do them during the relationship.
Yeah, absolutely. So as part of just the constant review of your financial position, we look at them and go, well, we did this 5-7 years ago. In that period of time, we've now done this. why don't we look at changing the terms of that agreement? We'll get rid of the old one, we'll put in place a new one, and then that will set forward what happens if we separate into the future. Again, hoping that they get signed, put in a drawer, and never get looked at again.
Yeah. We hope for the best, but plan for the worst.
Exactly.
Right. Now, the third one we can do is a financial agreement on the ending of a relationship. Is that?
Yeah.
Right.
So that's the 3 stages of financial agreements. When we have separated and you've reached an agreement on the division of your assets, whether that's parties have direct discussions and come to us and say, this is what we've agreed on, or throughout the course of solicitor-led negotiation, we've got to the point of reaching an agreement. We then have the opportunity to consider what is the appropriate documentation for that. And when we choose a financial agreement, that's what we put in place for the division of our assets. So say we have the family home, and it's been agreed that one party is going to keep the home and pay the other out their share of the equity. The financial agreement can say that within the relevant period of time after the agreement, this person transfers the house to this person pays that person their cash settlement.
Yeah. I get this one a fair bit. And I love a situation where parties can work out an amicable result on the ending of a relationship. But, do we really need the agreement? Like, we've worked it out amongst ourselves. Can't we just agree?
You can, but you shouldn't.
Tell me why.
At that point in time, obviously there's a high level of trust, which is really great, and things are amicable. That's great, again, at that point in time, but things change. And for many and varied reasons, that level of agreement and that amicable relationship can change. And if you haven't formalised your property settlement agreement by way of a financial agreement or the alternate, which is your consent orders, you are open to the other party going, you know what, I'm not happy now. I think I'll just have another little go and see what I can get now. The additional benefit, again, with the property transactions that occur pursuant to these agreements is the stamp duty exemptions that follow from them as well.
Yeah. So if you don't want to be looking over your shoulder and worrying about someone coming back once you've reached an agreement, do it properly, get good legal advice.
Absolutely.
And get a binding financial agreement.
Get a binding financial agreement, which is something that we here at OMB Family Law do regularly, and more than happy to assist.
Well, fantastic. Thanks so much, Abbi. I found that really informative, and appreciate you coming back on the OMB Law Board.
Not a problem. Thanks for having me.